first before. All right, so, all right, let's see. Hopefully everybody's in. I have 10 participants. Good afternoon, everyone. This is the last of the NJAPM series, webinar series, hosted by Bruce Matez, who the powers that be decided that he needed to be knocked out. There is such a thing as not being as good as in person when your internet does not work. But anyway, without further ado, I'm going to introduce Laura Hester and Rick Stein and Theo Chan, who are all going to tell you about civil mediation. Thank you.
All right. Good morning, everybody. Good afternoon, everybody. This is Rick Stein. I am going to give you a little idea about how we plan to do this. When we were discussing the manner of presentation, Bruce is back. We decided we had some questions that we wanted to hear from each other about. So, and we thought some of those might be of interest to you as well. So what we're going to do is we're going to take turns asking each other questions and answering those questions. I think Bruce is back, and I think what he would say would be to put your questions in the Q&A, and we'll answer them at the end.
Sounds good to me. I will do my best to monitor them, but my internet went out twice at this point. So okay. Laura is now the host, just in case there's a problem.
Okay.
And Suzanne should be on here somewhere if there's a problem too. So
Suzanne is on.
I'm here, and I'll help with any Q&A too. Okay.
Thanks, Suzanne.
I'm glad somebody else other than me is the host. So. In any event, we're just going to kind of go through some of our background and the title of the seminar, Success Stories. I hope that's true to some extent, and I hope some of you get some information about how you might, have a broader application of your practice. My name is Rick Stein. I'll let everybody introduce themselves. I've been doing mediation for 35 years. I've been doing arbitration for about 10 years longer than that. I actually came to mediation through arbitration. I'm a construction lawyer. I was in-house with a construction firm for 20 years and did a lot of arbitration when that, my time there, and decided to try to get into neutral work almost full time. And I've managed to do that. Laura?
So my background was as a litigator. I clerked for a federal judge on the First Circuit Court of Appeals, and then went to Chicago and worked at General Block for 22 years, where I was litigating and also mediating, although the style of mediation was remarkably cavalier. We would go, my partner would come in the office and say, "We have to go see so-and-so to mediate this case, pick up the file." And then I went to AT&T, where I was chief of litigation for a little more than 9 years. And when AT&T merged, or was taken over by one of its baby bells, I decided that I wanted to change to try and do mediation and arbitration. And that's when I began training, and that was 2006-07. And I've been doing it pretty much full time ever since, although in the beginning, full time meant learning. So I'll turn it over to Theo.
Great. Good afternoon, everyone. My name is Theo Chan. I spent 20 some odd years as a commercial intellectual property litigator. And then I made the transition about 10 years later than Laura to become a full-time arbitrator and mediator. I've been an arbitrator for about 15 years and a mediator for a little over 10. And I've been focusing on commercial intellectual property matters most specifically, but also some entertainment and employment work as well, which mirror some of the practice areas I was doing back in private practice. So with that, I think I'll turn it back over to Rick.
Okay. I think
I'm the first question.
Oh. Yeah, I think Laura has the first question.
Okay. So I'm going to ask Rick first. how did your interest in mediation, actually in doing mediation as a mediator, come about?
Yeah, as I said, I was in the construction field. Arbitration's been around for decades. Mediation was a relatively new fad, if you will, almost in the late 80s. And I've been doing arbitration, and it made sense that mediation was something the construction industry adopted early. And since I've been doing neutral work anyway, to some extent part-time, I just decided to expand my practice. I was involved with the state bar dispute resolution section and the court when the court adopted the mediation program. I was one of the first original group of people who were trained. This was in the early, I guess it was in the 90s. I'm losing track over time, but when the court program got started, I jumped into that with both feet. I signed up for all of the counties, and I signed up for a whole lot of case types. Originally, it was 3 hours for free, and so there wasn't a lot of revenue generated from all of that interest, and there was no Zoom, so I was running all over New Jersey. But I got a lot of experience, which I think was important at the time.
Theo, I was there at the beginning with you, I think, sort of.
Yeah, I mean, I think, my exposure to mediation really came about because I was still in private practice, and at a time when a lot of federal and state courts were sending cases to mandatory mediation, I didn't know a thing about it. And the partners I went to kind of had the same reaction that Laura described before. They kind of didn't really understand what it was. They really couldn't advise me. And so I wasn't advising the clients very well. At the same time, I had also clerked like Laura did, and I was sort of interested in seeking a position in the judiciary. But it seemed like that's a very uncertain career path. But as I looked into it some more, I found that, there were people like Rick who were actually doing mediation full time, and maybe you could actually make a living doing that. So that's sort of started my path towards thinking about mediation. And then I did what a lot of people do, right? I volunteered in the courts. I took a lot of training courses, and I found a way to transition out of that full-time private practice position into a full-time neutral career. So that's kind of how I came to mediation.
So Theo, you're supposed to ask us.
Oh, yeah. So I did mention training just a minute ago, right? So I think we all agree that anyone could, at any moment, hang a shingle and call themselves a mediator, but it's probably a good idea to get some training. So the question to you, Laura, is where did you get yours?
So one of my hallmarks is overdoing training. So I got it in very many places. I did the Linda Siegel, the CPR training.
That's Linda Singer? Was that Singer?
Linda Singer.
Yeah.
And Michael Lewis training. I did a 40-hour training with Jack Himmelstein's group, Understanding in Law, which actually is not that common, especially for commercial mediators, because the vast majority of the people in the course were matrimonial. But it was fabulous for me, and their model keeps everyone in the room, and I don't think a lot of people are comfortable with that. And so
why did you pick that latter training program? Because not everyone does that one, right?
No, very few people do it, I think, in the commercial world. A lot of people do it in the matrimonial family law world. I don't know. I think I picked it because it was not quite the Bernard Baruch model. It was a different concept of sharing understanding with the parties, and the way that they go behind to get to the needs and true interests of the parties is a little bit different than what you're trained in other settings. I have to say that one of the benefits of getting a lot of training is finding your own model. You you can't really just follow someone else's steps. This is all about trust and a kind of communication with the parties. And if you're not comfortable in yourself, ultimately, you can't really achieve what you're supposed to achieve. So this was true for me even as a litigator. One of the reasons I went to my firm was at a time when there were very few women in the litigators in the profession, one in Chicago. In fact, every place I interviewed, they say you have to talk to her. You know, she was at a different firm. So one of the reasons I went to Jenner & Block was there were many different models of litigators, and I chose bits and pieces of the way they examined or the way they all were high on preparation, but the way they prepared might be different and the approach to the case might be different. I think the same thing is true for mediation. Many people have very, sometimes big and sometimes small variations in the way they approach mediation. And if you are exposed to more of that, then you can incorporate in your process what you are comfortable doing. That's where you have to get comfortable. So I thought the Himmelstein Friedman training was amazing. So Gary Friedman, who uses that, has done it, for example, with the San Francisco Orchestra. He had a dispute between the orchestra and the management. And so being able to manage large groups and keep people in the room, keep people talking. I ended up having a mediation between two not-for-profits that had grown up together and the leaders were leaving. Both of the original generation were leaving, and they had all of these issues dealing with each other, how to get credit, how to get money, how to get, so if I hadn't been able to keep them in the room, I don't think that could have resolved. So I think there are some techniques that are worth learning from different things that you can import into your own technique. Rick, what was your training?
Well, my training in arbitration was through the American Arbitration Association. I actually, for them in the late 80s or 90s, at some point, the AAA decided they needed to train all the arbitrators, including arbitrators who had been on the panel for a long time. And there were like 35 of us who they trained, they did a train the trainers, and I went all over the East Coast. I went out as far as Minneapolis and trained many of the arbitrators. In terms of mediation, when the AAA started offering mediation, they did some training that I was initially took, and then I was involved in doing again some of the training. And I took from Eric Max, did the training for the first group of court mediators, and I, pretty much the whole time I've been doing this, I have actually, to the extent I've been invited, participated in doing training. And I always tell people, as long as I've been doing training, I learn as much being a trainer as I do, in an audience. So that's something that's very important to me. In terms of the kinds of cases I do, we typically use a caucus model. I have not. And I do no family mediation at all. I just do civil mediation. And I have not seen, I've not had cases where, although I've tried to keep everybody in the room, I have not been successful at doing that in a way that got us all the way along. We've gotten very far, but at some point, I think the attorneys want to be able to get with their clients outside of the presence of the other parties. So that's one of the things that I have found. But Laura is absolutely right. As many styles and as much information as you can learn from attending trainings and being trained, the only way that you are successful in mediation is if you're true to yourself. And that involves a lot of soul searching, what works for you, what doesn't work for you, how risk averse or conflict averse you are. And you know, over the course of time and over doing a lot of mediations, you get to the point where, you know, you have a confidence that the kinds of things that you think are the right things to be doing, you know, and you have to be comfortable in that, you know, your style, and you have to be comfortable with the parties. Otherwise, you know, without them seeing that you're comfortable and seeing that they can trust you, you know, you're wasting everybody's time and money.
One thing I will say about trainings, after you've completed the fundamental trainings and after you've incorporated some comfort so that you feel like you can deal with parties, there still are wonderful trainings to be had. And I will say that some of the things I've learned that I would call advanced training have been really miraculous for me. For example, Doug Knoll does a training in identifying emotions. And I was having some trouble during a period where some of the lawyers would try to intimidate me. And they would say things like, and I'm small, and that people use that in a bad way, some lawyers. This happened to me also as a litigator, so I wasn't unfamiliar with it, but I didn't like it. So a lawyer would come into my caucus room and say, if you were a good, you know, mediator, you go in there and tell them, basically bid against yourself. So it would, you know, raise the hackles on my neck, and it would really, in a way, interfere with my own process because I got personally engaged. And Doug Knoll did this training where he said, if you can identify, one of the very few ways you can lower the temperature is to identify the emotion. Just saying it, and even if you're wrong, the person will correct you, so that just by doing that, you make some progress. So I had another instance where a lawyer came into my caucus where I said, we're good, you know, you made it. I offered him, that was a ridiculous response. You know, if you were a good mediator, and I said, oh, you feel disrespected. And he said, oh, well, it's not about me. I said, great, let's figure out the next best step for your client. And it just completely changed everything. You know, I didn't have any more hostility from him. I didn't have my own reaction to deal with. So I would point out that it's not just the beginning trainings, it's ongoing trainings. You can learn so much from. And Rick said teaching. All three of us have done quite a lot of teaching. Both Theo is currently teaching at a law school. I taught at a law school. Rick teaches constantly. We all teach, you know, the adult courses for the mediators and arbitrators. And that's a way of forcing yourself to learn things, whether it's case law or new developments or new ideas. Rick and I are working on a project to do international arbitration mediation. So, you know, it's really a constant thing that gives you an opportunity to keep abreast of everything.
So obviously that we're all strong on the training aspect of things, and just in terms of experience, Theo, where did you gain your experience?
Well, after getting the training, one of the places I started, as I mentioned earlier, was volunteering in the courts. And the place that I found the most helpful was the Southern District of New York's program, which is an all-volunteer program. And I don't want to get off on a tangent on whether and how much free time mediators ought to be donating to the courts. But one of the great things about that particular program is that because it's a free program, there's an abundance of work. Any new entrant who wants to become a mediator, there's guaranteed work on that court roster. And so you could wait and have a case spun out to you, or you can just call the administrator and ask for cases. And that's what I ended up doing, was asking for a lot of cases so that I have a chance to put into practice what I've been learning in the training. I also took advantage of, as I started to get to know other mediators, shadowing them, asking them if I could just sit in and listen to them and see how they worked, and asked a lot of questions, and I learned a lot of different techniques and things that worked and things that didn't work. And as Laura said before, some things are suited for you and some things are not. And I think you learn watching other people do things, whether or not it's something you feel comfortable doing. After, getting onto a number of other court rosters, then I applied to non-court roster, private organizations or agencies where there were other types of work available, and also getting more pay as opposed to just volunteering all my time. And then, of course, readying yourself for private ad hoc mediations, because to the extent that you don't know, obviously, most of the mediation, the vast majority of mediations in this country are not done through formal rosters, but they're actually done privately. You'll get a call privately from an attorney or an in-house counsel, or sometimes a party themselves, asking if you would be interested in serving as the mediator. And that's how most mediations are actually arranged and handled. But in order to get to that point, participating first in the court rosters, super helpful in getting your name out there, getting the organized bar to recognize you as someone who is now a mediator as opposed to a private practitioner, because it is a transition. You're sort of changing your persona from being a simple advocate to someone who's doing a different job altogether. And in some respects, you're sort of reintroducing yourself to the marketplace of attorneys. And so that's basically how I started to get experience, and then built from there. I will add that, of course, the court rosters usually, I'm not sure about all of them, but usually you have to be an attorney in order to be on the court roster. So for those who are not attorneys and attending this program, there are other programs out there that do not require you to have a law license in order to volunteer or spend time being on their roster, including community dispute resolution centers in New York, for example. You don't have to be an attorney. I believe the Better Business Bureau has a mediation program. You don't have to be an attorney. FINRA has a mediation program. You don't have to be an attorney. So there are other outlets. So you don't have to be restricted only to the court programs. Obviously, as an attorney, that was a natural fit for me. And having been a litigator and a trial lawyer, it was a natural fit for me to work with counsel who are having cases about ready to go to trial. So that made sense for me.
All right. Laura, what about your experience?
So one thing I want to point, yes, mine was predominantly court, the initial experience. And still, I do a lot of court mediations. During the pandemic, I was I felt it was a public service in a way. So I really continued to do that. I do object to some of the free time aspects of it, but it is also a free way of advertising, because it's a word of mouth situation where if you do a really good job for a couple of big firms in New Jersey or a couple of big firms in New York, people do actually mention it to other people. And I will say that one of the problems I see in this profession is that the people you know best have a hard time using you as a neutral, because you have the potential for the other side disqualifying you when you disclose, oh, I worked extensively with that person. So recently, I just got a case from a person who was my attorney at AT&T on a major set of matters. And it's interesting because I think that was sold to the other side as because I would have possibly more influence with the one that knew me. So I think there are some things you can talk about that way. I think good advocates might want to pick a mediator chosen by the other side or not known by the other side, with the hope that they can have them help them. Because neutral isn't really neutral, it's pro both sides.
I describe it in my opening little remarks that I give in a mediation that the attorneys in the room are advocates for their client, and I'm an advocate for settlement. That's kind of the way I try to make one of those distinctions. I had mentioned I had joined all of the counties in New Jersey when that program first started. I also got involved in, and I still do, community mediation, municipal court mediation in a variety of towns in Mercer County. I don't do much of it anymore, but I still do some, just because and that again is the community mediation in New Jersey. I think most municipal courts have to have it. Most of the mediators in those programs are not lawyers. A lot of them are retired from other careers or just in an effort to either stay busy or help out. But the court programs, and as I said, the construction industry had been doing so much arbitration, and I had been doing enough arbitration that a lot of the construction lawyers knew me. And when the industry started, and again, they were a little bit ahead of many industries, they were pretty much on par with the court system for how mediation developed. I was able to, I had already had a group of people. I was active in the construction section of the state bar, and that's a fairly small group of people who specialize in that. So I was known to people, and that, being known in the business, I get asked about other mediators frequently, and I know attorneys, when they get a referral from the court, one of the things that is frequently done, is asking within your firm or asking other lawyers in the business, what they know about this mediator who's been appointed. And I have in a number of cases, the court allows you to replace a mediator, allows parties to replace a mediator. I have replaced a number of mediators in a number of cases. I've also been replaced by other people for a variety of reasons. Usually I never figure out why. One of the things that happens more frequently in the last few years is that if parties are looking for, a lot of parties are looking for a retired judge. So even if I'm on the rotation, my name comes up on the wheel, the parties will say, they'd rather have a retired judge. So that works both ways. But
that's a good segue. That's a good segue.
Actually, before you go there, Laura, before you ask the next question, I just want to note that Anju Jasani put in the Q&A the Rule 1:40 criteria for admission, which notes that actually you don't have to be an attorney to be on the New Jersey court roster. So that's I just want to make that correction to make sure everyone knew that in this seminar.
But you do have to in New York, I take it.
Yes, correct.
In some of them, I think there may be some municipal mediation programs that don't require it, and I'm not sure about the EEOC either. They may not require.
They don't require a mediator to be.
And the Postal Service, which if you can get their training, is fabulous. I don't think they've been giving it as much, but that is a really wonderful opportunity. But the segue I was going to use was into referrals and conflicts, and how do you both deal with that? Do you deal with that very differently in mediation versus arbitration? And what kinds of disclosures do you make that are sort of general disclosures? I got asked about that recently, and some people don't really think mediation is an issue. I think mostly the parties won't find it to be an issue, but I make the same disclosures nevertheless.
I make the same disclosures too, and I laugh. I have a disclosure sheet, a couple of pages long, that I can tailor to particular cases, and I tell people I use that disclosure statement even when I don't have any disclosures. I mean, it gets to the point, and for arbitration, certainly, parties who are unhappy with your arbitration award may root around and try to find some reason to overturn it, some relationship that you failed to disclose. When I'm doing a court case, in my initial letter that I send out on every case when I'm appointed, I describe any relationships I have with any of the attorneys. And having been doing this so long and having been involved as much as I was in the Bar Association, I know an awful lot of lawyers. And the fact that I may have been at a CLE conference with them or a cocktail party with them or something, I have a generic, I'm casually professionally acquainted with many lawyers in New Jersey and many law firms. And, I haven't checked to see whether any of the lawyers in the firm that's in front of me necessarily are, and lawyers move firms too. I've got caught up in a situation where, I didn't think I had a disclosure with a law firm, and turns out that, somebody who I had spent quite a bit of time with had moved into that firm. So I had to, after the fact, I had to make a continuing disclosure about that. But in terms of conflicts, I will just lay out. There are some situations where I will just turn down a case. If I'm doing an arbitration with a lawyer or a law firm and I get another opportunity to do something with that same firm, I will very rarely take that second case. Luckily, I'm busy enough not that that's not a big burden on my on my caseload. But and I've had I don't have real good records of every lawyer who's been in front of me in a mediation or arbitration in the last 30 years. I try to do what I can to figure out parties. I'm pretty good with names and relationships. Lawyers, not so much, but I research what I can and make those disclosures.
Yeah, I'll just add that from a teaching training perspective, I think that the standards for disclosure to the parties of any relationship that might reasonably affect impartiality or lack of independence in the eyes of the parties is the same for arbitrators and mediators. I think the consequences, like Rick said and Laura said, are different in those different modalities. But I think the level of disclosure or what triggers a disclosure is exactly the same. So I believe you owe to the parties to be honest, fulsome, robust in your disclosures, and so that they can make an informed decision as to whether to retain you as a mediator. And look, if it turns out that I don't get that gig, then I'm more than happy to refer that matter over to a colleague or someone else who handles that kind of a dispute. There'll be ones where people have no issues, like Laura said. I think in most cases they don't really care because you're not making any kind of binding or final decision on the merits of the case. But sometimes they get bothered or troubled by something, and that may be enough, and that's perfectly fine. Just happens.
So the other thing I do is, like Rick, I do a general disclosure, and I edit a lot of papers. I edit a journal. I publish in a lot of things and in books. And so I'd say, and I no longer have access to the databases of the law firms or the companies that I work for. I say all of that. I say I'm not searching listservs. I am listed on LinkedIn. I am listed on, the Silicon Valley. So I state the different organizations that I'm associated with, that I've taught at, or that I speak for. And I say I'm not searching those. Sure. I am not searching to find out if anybody is associated with those entities. If you are concerned, I ask the parties to please look at their own information before the dates of when I left the company or the law firm, or, if any of these things that I'm not searching. I try to put as much burden on them to come up with the conflict in advance, because that does help if, as Rick says, parties go after don't like the result and try and look for something they can raise. So I think that's very important. And I think this also relates to, I noticed something that Rick said about his participation in the construction industry. I think I, for one, have found that the reality is if you want a significant private case, you're going to have to show that you're expert in the field, in the underlying field, whether it's telecommunications in my case, or construction in Rick's case, or some form of intellectual property in both Theo's and Mike. I mean, I tried to break into other areas. I even developed and taught the bankruptcy mediation program for New Jersey, and I have never gotten a bankruptcy referral.
I'm doing 3 of those right now, and
oh, yay!
But
Great.
It's you know, I've probably done, since you did the training, which was a long time ago, I've probably done 6 or 8 of them. But you know, and actually I think the American Arbitration Association, in its rules, requires parties to do their own searching of relationships with proposed arbitrators and mediators. And in my disclosure, I say I expect the parties will do that too, and let me know if I missed anything, which is just kind of a belt and suspenders for that. So
Yes.
we're moving right along here toward
Yeah,
the
so let me ask
hour.
Laura the next question. I mean,
Yeah.
you know, we talked a lot about getting into the field and all the training and now conflicts and disclosures, but you tell us a little bit more about how do you go about finding new work?
So, you know, I think this is not so easy. And I really do recommend that if you have another source of income, it takes a long time before you're really able to sustain yourself in this profession. At least that's what I found. So I guess this partly came from practice. Staying top of mind is very important, and establishing expertise is very important. So in publishing, writing, speaking when you get a chance to do it, and make the chance. So one of the things I mentioned is your own area of expertise. You have some area of expertise. Start an ADR column in the journal of that expertise area. Start an ADR group or join the ADR group in that professional organization that you already belong to. Start writing. And one of the easiest ways to start writing is case analysis. You know, there are always new cases coming out. You can always pick a case and make a comment. There are new statutes coming out, or there is legislation proposed. There are things that you can notice first. And if you're first to notice, you're in there at the beginning, you know, so that's really critical. This whole AI thing now has a lot of potential discussion areas and presentation areas. Look at Susan Guthrie's career, because she has made an amazing career out of the change from in-person during the pandemic to Zoom and now to AI. Think about these new developments as a way to distinguish yourself in the arena. Even if it's a small item, it can be a way of getting seen. Theo has a column, a regular column. Rick speaks and publishes, I think, widely. Yeah. And I try to publish quite a lot. LinkedIn is also very important. Making sure that you feature yourself whenever you're doing something with others, or feature others, because you know your name comes up when you say something about someone else. So that's important.
And hopefully they'll say something about you as well. So Theo, did you put together a formal business plan of any sort? And this ties into the next question too, which is marketing, websites, and we've talked about organizations, we've talked about publishing. You know, what did your business plan look like? Frankly, I kind of stumbled through my evolution into ADR, so I did not have a business plan as such, but
Well, I think we all stumble a little bit. I mean, this isn't like a tried and true career path that everyone knows to a T. So, but I'll sort of go off a little bit on what Laura just started saying,
Yeah.
which is and tie it together, that it's so important to acknowledge, right, that you are the brand in this space, right? People are hiring you to be the mediator. So anything and everything you do should reflect the brand that you seek to establish in the marketplace. And so, yes. When I first got started, I would annually write a business plan to help me plot out the next calendar year. It would include actual booked and potential speaking engagements, as well as actual and potential writing opportunities. I mean, in the beginning, I would really try and strive for anywhere between 10 to 20 speaking gigs a year and write about a dozen articles. That was my plan. I didn't always hit those numbers, but that was the plan. And ultimately, I found the speaking gigs to be a whole lot easier and more satisfying. So I've now increased that to about 40 a year. And that's really what I've been doing the last few years, and kind of cut down a lot on the writing because it takes a lot more time to do that. I also co-branded with Lexis to become a Lexis practice advisor. So besides the regular column that Laura mentioned, I write practice notes for Lexis that go on their website, and I get the co-branding benefit from that. My business plan would also include goals and objectives on how I would expand my brand and where I was going to invest both time and money into the practice, as well as origination targets, so you can see how you're doing over the course of the year. Just to give you an example, like for several years, I was a member of the Copyright Society and still a member. It's the premier copyright law organization in the US. That's where I spent a lot of my private practice time in copyright work. And at one point, I had served as the national secretary and national treasurer of the organization. And then I took some time off to be with my family and also to build this practice out. But I had always put in my business plan my desire to return back to leadership. So we had an annual meeting last week where I was elected the national vice president, which is a 2-year term. Thanks, Laura. And then after that 2-year term, you automatically go up the ladder to become president for 2 years. So now I'm locked in basically until June of 2028. And that's part of my business plan. And these positions, no doubt, will include a lot of work on my part. But this is also an organization that I know really, really well. I've been in it since 2007. And I care a lot about it and a lot about the members in the organization. I also have a robust network of contacts, and I typically generate, a decent amount of work from the members through my networks and contacts there. So all of that goes into my business plan. I mean, I will say, Rick, though, that after several years, I don't write like a formal business plan anymore. I still write like a sort of almost like a simple checklist nowadays.
Things I want to goals, right?
List of goals, yeah. And look, the bottom line is it doesn't have to be anything formal or something that you learn at some business school, or it doesn't even have to be a particular format. I think just doing the exercise of putting together a plan of some kind helps you stay focused and sort of minimizes what I will characterize as aimlessness throughout the year, right? Because you don't know where you're going, you don't really know what you're trying to accomplish. That said, I also think that this is a field where opportunities can arise from very unexpected places and sources. And so I think it's important to remain nimble and flexible so that you can adapt when those circumstances arise and you can take advantage of them. I mean, I think if I sort of rigidly adhered to some kind of business plan, I think I might have missed out on a lot of wonderful things that would have happened to me throughout the various years I've been in this field. So a business plan is a good guide, but I think be open to the possibility.
So I'd just like to pick up on one thing, and it's true for all three of us. The active participation in organizations is really critical to keeping yourself top of mind, developing yourself, and creating a community. So all of the things, all of us belong to organizations that are neutral focused. That is the DR sections of the various bars. We're all members of the Garibaldi Inn. Those are for us, I think, a sense of community and a place of learning. But that's not where you're going to get business. At least not until you might be chosen, say, by 2 other arbitrators to be the chair of panel. And that's not really at the beginning. So I think it's very important for you to sit down with yourself and say, what organization maybe that I already belong to or that I could belong to as in a substantive area, in a field where the other lawyers might, or other non-lawyers like engineers or IT specialists or something else might choose me to resolve their disputes. And how do I get engaged? Joining as a member is useless. Okay, really, you need to participate in a serious way. And my experience is, as long as you contribute, you'll be in the leadership within 3 or 4 years. I mean, because they need people in leadership. They need people dedicating themselves to the work of the organization. If you actually work, you will make progress toward the leadership.
If you volunteer and you actually work, they will give you more work to do.
That's so true.
Right up until you get to lead the organization. But yeah, that's you know, again, organizations publishing, it's, as Laura said, top of mind, which I think is a term I heard in marketing 101. But you know, if you're, and again, you need to reach out beyond the ADR community. You know, very important. And I mean, you don't have to have any particular subject matter expertise to be a good mediator. The issue, though, I think, is that in many cases, the parties looking to do a mediation, rightly or wrongly, look for somebody who has that experience, or who you know, who has that expertise. Now, you know, when I started doing court cases, I did lots of things that had nothing to do with construction, and I managed to find out. And when we do the training, the mediator standards of conduct, the substantive expertise that you have to have only has to be enough to satisfy the reasonable expectations of the parties. You know, so when I get a case that's totally outside of my realm of experience, you know, if I think the parties might be looking for more experience than I have, I just ask them. Usually they say, no, you're fine, because, you know, the lawyers will, a lot of lawyers like to think they know more than you do about the particular area of law. So.
I would also say, in my whole career, and even doing technology, when you do patent cases, you can't know, you know, unless you have you're an electrical engineer, for example, and you know that very specific area. You don't, right. You can't know enough. So I always thought of myself as a translator, because the judges don't know any more than I do, and typically, and you know, if you're willing to learn, they can teach you. It's the lawyers like to have the shortcut of not having to teach you the jargon, but it's not really a necessary element of most things.
That's why people go to arbitration instead of going to juries. That's a shortcut. Yeah. Getting somebody who knows the business.
I think Bruce might want to say something.
Yeah, Bruce wants to tell us it's time for, if there are questions, we'll be happy to address them.
You've got about 10 minutes left. There was a question that Theo answered, but I thought maybe that you guys want to answer it verbally, from Glenn, who asked, for generating income, what's proven to be more lucrative, mediation or arbitration?
I'll start with that. I mean, do you realize the number of mediations you need to have in order to make a living? That's a huge number. There are people who do that, but I actually think I could count them on my 2 hands, the people who make a good living just mediating. So just think about the reality.
That wouldn't work for me. The mediations tend to be a lot shorter. The, you know, overall billing typically is a lot lower than an arbitration case. You know, but and people ask me how much time I spend doing both, and it varies. But I literally sometime last year I keep a count of the number of cases I've had, and within 1 week, you know, over the only 1 week difference between when I recorded my 1,000th mediation that I handled and my 1,000th arbitration that I handled.
Well,
So, you know, it's half and half.
I was just going to add that I also think the word lucrative is kind of an interesting question, because all three of you, do you all charge the same thing hourly for arbitrations and mediations?
So it certainly depends. If you're doing it for the court, you can't. If you're doing it for under specific rules, you often can't. So, but you know, that might vary too. FINRA is arbitration for me, but is very low rate. So it, I don't think I can answer that question exactly. I do charge the same rate for the AAA arbitrations and mediations.
I charge very close to the same rate. My rate's a little higher for mediations, but
yeah, I think my rate should be higher for mediations. I have to give that some thought.
Yeah, I've long thought that, I think mediation is harder work actually per hour. And so I think that it warrants a higher rate. But to be honest with you, I don't charge a higher rate. I charge the same privately for arbitration and mediation simply for administrative ease. I don't want to have so many different rates running around. It's very hard to keep track of that. And I don't want to misinvoice or misbill someone. So I just keep it the same. It also depends on how much of one you want, right? I tend to do only about 15% mediation, and I don't really want that much of it. So I actually have thought about raising the mediation rate so that I get less of it and more arbitration work. But, haven't really tried that yet. I don't know if it would actually pan out the way I think.
Yeah, and I recently got offered a private mediation, and I put out my rate, and this was a person I'd worked with before, said that's kind of high for these parties. And I said, okay, I'll give you a discounted rate. I think you have to be a little flexible, or you're doing business.
We have a question here. To what extent is your mediation business limited by jurisdiction? I mainly stay on the eastern seaboard, in the Northeast. I will go outside of New Jersey as far as anybody will have me. And arbitrations, frequently are, if it's a panel of 3 arbitrators, they may be in various parts of the country. Cases may be in different parts of the country. But, and I'm starting to do more international work now. So you're going to be known the closer to home you are. I was active for many years in the American Bar Association construction law section. So some of the people I would meet at that and work with at that, some of the programs we put on, I would get occasional calls from the Midwest or the South or somewhere with, somebody looking for either a mediator or an arbitrator. But, most of the work tends to be in the Northeast.
Laura, Theo, you have anything you want to add to that?
I have gone elsewhere around the country to do different things, but I think the likelihood is somebody's searching for people in the general geographic vicinity, unless it's a case, the cases that I've had that are cross country, and sometimes people specifically want people not from their location. So there is that opportunity, and then you talk to your other arbitrator and you say, let's pick someone not from your state or my state. We'll pick someone, in a different state. So it depends on the situation, really. But I would say the majority of my work is Northeast to mid-coast.
Yeah, I'll say the same. I mean, in the sense, my practice generally runs from like Connecticut to Pennsylvania, but I do have matters outside of that geographic span. I don't limit myself. by jurisdiction or geography. I answered this in the Q&A too. I don't limit myself by jurisdiction or geography, but I think, most people tend to pick mediators from the local area because A, they don't have to pay for travel for the mediator to come to them. And secondly, they may want a mediator, for example, who knows the judge or the court before whom or which the matter is currently pending. So then that insight I may not have. And so they want someone more local. I also don't spend any time marketing in places where I know the competition is fierce. Like California is one of those places where competition is very, very fierce. JAMS has a really huge lock on mediation over there, ADR services also. So I don't spend a lot of time trying to market myself in California.
In terms,
well, folks, sorry, go ahead, Rick.
I was just going to say, we had one more question about technology, but, we all learned how to use Zoom when we started to have to, and still do it to the extent we can. Laura?
Yeah, I do think technology is really important. I think knowing how to use it comfortably is something, as some people have trouble with. You got to stop having trouble with it. Learn it. It's not, if you have to take lessons, I actually paid Susan Guthrie to teach me private lessons of managing all electronic. I learned how to use PDF Expert because it became impossible to use paper exhibits. Turning them, doing Zoom, taking notes, it just didn't work. So I needed to learn that, and I did learn it. I mean, sometimes you have to spend a little more time learning something that you didn't really want to learn, but it's worth it. It's more than worth it. You're the expert on that part of it.
Laura, I just want to add to that you can find instructions to do just about anything on YouTube today. So if you are concerned about the cost of hiring someone like Susan or somebody else who has that technological knowledge, start with just YouTube videos, and a lot of times you can learn a lot.
And Zoom has very good videos also.
Yes, Zoom has a lot of webinars for their own use, and the way that they integrate with other technology as well. So, all right, so we are at 1 o'clock.
We
so
are at 1 o'clock.
Laura, Rick, Theo, thank you so much for doing this.
Thank all of you for attending. Appreciate the invite, Bruce.
And we are off now for the summer. There will not be a webinar in July and August. We'll start again in September, the 3rd Monday of the month. I'm in the process of planning the webinar schedule for next year. So if there's a topic that you're interested in that you think we should tackle, or if you are interested in presenting a topic webinar next year, please get in touch with me in the next week or 10 days, 2 weeks. Because I'm really going to start working on planning that. I do know that we have a couple already scheduled. Lawrence Eichen has already agreed to do a Tech Time update. And we're going to have a program on Social Security benefits, and then hopefully a few others. Just a reminder, there was no CLE credits for today's program. And thank you all again. This will be available on YouTube hopefully next week. Thanks.
Thanks, everyone. Have a great summer.
Have a good